Hi, everyone. My name is Kelly Preston, and I am a partner at the law firm Devry Smith Frank. We are excited to talk to you today about some issues that we believe have arisen through recently in the real estate market, particularly as a result of the COVID-19 pandemic. And, that has brought a whole slew of issues. So we're going to address those. We're going to address kind of what I would say the more common issues that may arise in real estate transactions. Before we get into the lunch and learn, however, we have exciting news for those who have not yet heard. Devry Smith Frank has merged with Woitzik Polsinelli, and that is exciting news for us. We have been working on this agreement for a couple of years, actually. It's been kind of going on behind the scenes, and we're happy to announce at the end of 2020, despite the COVID pandemic, we were able to get the agreement done, and we have been very successfully working together. Woitzik Polsinelli is a longstanding and well-respected firm in the Durham region, offering great legal services with great staff at exceptionally affordable prices. And I think that is something that Devry Smith recognized as a definite asset. And we looked at Woitzik Polsinelli as a firm that could only strengthen and help us build upon the Devry Smith brand. So the idea is, together we are better. We are going to continue to grow, and our agenda is basically to have a complete full service law firm offering every area of law in Durham region. And we're very excited about this, and very excited about the new opportunities that we will have together. So some people have been asking in terms of, I work with Woitzik and I work with you. What do I do now? Where do I send my files? And, our request is that you continue to do as you are doing, even though we have merged, we are operating as two separate entities at the moment. So continuing with the relationships that you have built or would be amazing. And that would be something, in the future that may change, but for the time being, we are happy to service you at Woitzik Polsinelli and at Devry Smith Frank. So without further ado, let's get on to the lunch and learn. So a lot of my associates are going to be speaking today. So first up, we'll have Paria Rad, and Paria is going to be talking to us about the COVID-related issues that have arisen in the real estate market in 2020 and 2021. Following Paria, we will have our new associate, Ashley Almeida, which we are excited to have Ashley on board. And Ashley's going to be speaking about open building permits and what you need to know when you are preparing an offer in relation to open building permits. After Ashley, we're going to have Jason Lane, and he's going to be discussing the new build delays that have arisen as a result of COVID-19. As well, he'll review new build agreements, status certificates, and condominium resales. Vanessa Romanino is going to be speaking after Jason, and she's going to speak about estate matters that have arisen in the real estate transactional world. Following Vanessa, we'll have Andrina Menicosi, who's our family law lawyer, and she will be discussing property issues in cohabitation and separation agreements.
Hello, everyone. I hope you're keeping well and safe. Welcome to today's webinar. My name is Paria Rad. I'm one of the real estate lawyers and partners at Woitzik Polsinelli. If we've met before, nice to see you again virtually. If we haven't met, nice to meet you. I look forward to seeing all of you once we're able to meet again. I've been practicing real estate law for 8 years now. I joined Mark Woitzik's practice in 2015. And prior to that, I was practicing real estate law at a boutique Durham firm. The bulk of my practice is residential and commercial real estate law. Today, I'm going to be walking you through the virtual real estate closing. I'm going to speak to you about some of the emerging legal issues that I've seen cross my desk over the past year. And we're going to talk about tenant evictions during the pandemic. So in terms of the virtual real estate closing, the offer is being emailed to us. We're opening up a file for the client. We're meeting them remotely and virtually by way of Zoom, FaceTime, or if the client is not savvy with technology and they want to attend our office, we do have video conferencing set up here for our clients that they can utilize. Documents are being signed and scanned back or being signed through DocuSign. Funds are being exchanged electronically. So we're wiring funds into the client's account following closing, or if the client is unable to drop off a bank draft here for their purchase transaction, they can add us as a payee in their online banking and transfer funds to us utilizing that method. Keys are being exchanged through lockboxes, and post-closing documents are being exchanged by way of electronic methods as well to banks and other lawyers and clients. So for the most part, the transaction is being completed remotely. If you asked me a couple of years ago, can you complete a real estate transaction remotely, I would have said, no, that's impossible. But over the past year, we've all become extremely efficient and extremely good at getting the transactions done remotely. So I'm going to share my screen here with you. Here's a list of the emerging legal issues during the COVID-19 pandemic that I have seen cross my desk. The first one is the seller or buyer trying to use COVID-19 as an argument in order to argue termination of contract or frustration of contract, essentially. The second one is the seller refusing to provide a final walkthrough, contrary to the agreement of purchase and sale. The third one is tenants refusing to provide vacant possession and delay in obtaining eviction orders from the Landlord and Tenant Board Tribunal. This has been extremely challenging during the COVID-19 pandemic. The fourth one is tenants refusing showings during the pandemic. And the last one is delays in new build construction projects, which have been very likely and very common. So last year, if you asked us, well, how are the courts going to respond to the frustration of contract arguments that exist? We would have told you that we don't really have a crystal ball and there's been no emerging case law and that the interpretation is still left open. Since then, there has been a new precedent, new case law. The case of Burrell and Burrell, essentially this is a matrimonial case, but it does relate to real estate law. In that the parties had signed an agreement of purchase and sale prior to closing. The seller essentially argued that the agreement is at an end because of COVID, because of health risks associated with moving. And the courts took a very strong position on this. The court said, no, notwithstanding COVID-19, you are obligated and you ought to follow through with your obligations pursuant to the agreement of purchase and sale. So the courts have been taking a very strong position on this. And essentially, you can't be arguing frustration of contract unless something is impossible to follow through with. And with real estate still being an essential service, with banks being open, land registry being open, transactions are very much possible. So the frustration of contract argument will not be looked at lightly by courts. Now, there is still an obligation to act reasonably with one another, okay? So although the case law says that they're not going to tolerate COVID-19 as an excuse for termination of contract, there is still an obligation on the parties to act reasonably with one another during the transaction. Okay, the second point that we touched upon was seller refusing to provide a final walkthrough, a final visit. It's extremely important for buyers to do one last walkthrough. They want to make sure that the property is still in the same position as it was on the date that they entered into the agreement of purchase and sale. So sellers trying to use COVID-19 as an argument in refusing to provide a final visit, final walkthrough. Essentially, the same precedent goes in that you've signed an agreement of purchase and sale. you are obligated to provide a final walkthrough, and you cannot be using COVID-19 as an excuse to essentially alleviate your obligation pursuant to the contract. Okay, so walkthroughs can be limited to one person for 10 to 15 minutes, sanitize hands, gloves, masks, even foot coverings. And even if someone was COVID positive, really a final walkthrough can still occur by way of Zoom. Okay, so a big issue that I see happen quite often, and I get calls about this weekly, is I want to take advantage of the high prices in the market. I want to list and sell my property. I do have a tenant that's on month to month. What do I do? Well, as of January 2021, Ontario paused enforcement on all residential evictions. In Durham, the Landlord and Tenant Board is extremely backlogged and is hearing applications from May 2020. Rapid evictions through the Landlord and Tenant Board is presently very unlikely. So what do our seller clients do, or what can they do if they want to sell and they're subject to a tenancy? One is cash for keys. So essentially, you are paying compensation to the tenants and asking them to leave in exchange for the funds. Now, if there's a tenant who's agreeable and if this is to occur, it's extremely important to be mindful of making sure that the Landlord and Tenant Board form N11 is signed, and making sure that that form is completed accurately and correctly. So in doing so, you can always give myself a call. I'm happy to take a look at the N11 and make sure that it's drafted appropriately, or the client can reach out to a paralegal who specializes in landlord and tenant board matters. But it's extremely important to make sure that the form is completed and completed accurately and correctly. Two, wanting to sell and you're subject to a tenancy, what can you do? You can always have the purchaser assume the tenant on closing. So as a seller client, you could have a clause in the agreement of purchase and sale that says that the buyer agrees to assume the existing tenant at the time of completion. So I've included here a standard AREA clause that you could use when drafting an agreement of purchase and sale, and when a buyer is willing and agreeable to assuming a tenant. Now, the other types of clauses that I've seen emerge over the past year has been essentially that the seller will give the requisite notices in accordance with the Residential Tenancies Act, and the buyer will agree to assume the tenant in the event that the tenant has not vacated at the time of closing. So this means that you're going to give out all the appropriate forms, landlord and tenant board forms, and in the event that the buyer has not vacated, then the buyer would be obligated to assume the tenant. And I mean, this is a great clause to use if you're acting for a seller, meaning that you're going to give the notices, but if the tenant is not out, then the buyer will assume the tenant and the transaction will get completed on closing. Now, when you're acting for a buyer and you're assuming a tenant, you want to make sure, provided that the buyer is agreeable, you want to make sure that there's additional clauses to protect the buyer client. And in doing so, you want to have general warranties in the agreement of purchase and sale that are more detailed. And those are warranties that the seller represents and warrants that during the period of the seller's ownership, the property has been rented in accordance with the Landlord and Tenant Board legislation, and that any increases have been effected in accordance with the relevant rent review legislation, and that representation will survive closing. Okay. Now, you do need to have more detailed clauses when you're acting for the buyer, and if the buyer is willing and agreeable to assuming the tenant. And those are, again, further clauses to making sure that there's no disputes between the seller as the landlord and any tenants with respect to the lease or repairs, So this is a further clause that you're able to insert in those agreements to provide further protection to the purchaser. You can also go a step further, and I recommend this, certainly, if you're acting for a buyer who's assuming a tenant, and you want to have clauses in there that you're getting a copy of all the leases, you're getting a copy of the rent rolls, you're getting a tenant acknowledgement signed, confirming that there's no disputes between the existing landlord and the tenant, and a direction to pay all future rents to the purchaser. Now, you're only using this clause if your client, if the buyer is agreeable to assuming the tenant. I mean, some purchasers don't want to assume the tenant. If they're moving into the property, obviously it's important to get vacant possession. You don't want to get stuck with a tenant that you're not able to evict and who may not be paying you rent. So if the buyer is intending on living in the property, then my recommendation is that you insist on vacant possession on closing. If you're acting for a buyer who's purchasing the property in order to move into it and make it their home, then my strong advice is to insist on vacant possession. Paragraph 2 of the Agreement of Purchase and Sale notes that vacant possession will be provided by the seller. You could go a step further and add in here that the seller ought to serve the termination notices in accordance with the Residential Tenancies Act, and to provide copies of those to the buyer. Or you could have even a further, more detailed clause asking for additional costs in the event that the seller is unable to provide vacant possession. And any extensions to the closing is at the sole and absolute discretion of the buyer. Now, we're during a time where the Landlord and Tenant Board is extremely backlogged. They're hearing applications from May of 2020. Each case is unique. Each case has its own particular merits and facts. I would strongly recommend that you contact us and that you ask us to draft or even help revise a clause that may be appropriate for our mutual clients. It's been a pleasure speaking with you. If you need anything at all, I do have an open door policy. I hope that you can give me a call, email me. I'm happy to address any questions or concerns you have. I hope that we can all be able to see each other once again very soon and to meet for lunch and coffee. And again, if you need anything at all, please connect with me. Thank you.
Hello, everyone. I hope you're all doing well. My name is Ashley Almeida. I recently joined the real estate group here at Woitzik Polsinelli in December of last year. Now, albeit I am new to the team, I am not new to law. I've been practicing for 7 years, focusing primarily in the area of real estate. So it would be my utmost pleasure to be able to assist you and your clients with any questions, concerns, or matters that you may have in the future. And I do hope to be able to get an opportunity to be able to meet you all very soon. Today, I'm going to be talking about open building permits. Over the course of COVID-19 and the pandemic, there's been this surge in homeowners doing construction and renovations to their properties. Understandably, people want to either invest in the space that they have been spending the bulk of their time in, or they want to optimize on this seller's market that we've recently found ourselves in. With COVID-19 concerns having taken the front seat of real estate conversations, and purchasers as well focusing on critical pieces to closing like their financing, insurance, and utilities, there's been this potential looming issue that often goes overlooked, and that pertains to whether there is an open building permit against the property. A building permit is a municipal authorization for specified work to be completed on a property. And some examples of the work would include construction, renovations, demolitions, or alterations, and so forth. Issued building permits ensure that a project will comply with the building code, as well as any applicable building, zoning, permitted land uses, planning controls, and safety standards in the relevant municipality. The application process for a building permit does differ from municipality to municipality, but the typical process goes as there's an application submitted with draft plans for approval. They obtain the official permission for the work that's going to be completed. once the work is completed, a final inspection is done to confirm that the work is in compliance with the issued permit that was given. And finally, if all goes well, there will be a closure of the permit that follows. Now, searching for open building permits does fall on the real estate lawyer's shoulders when we do have a transaction in our hands. But unfortunately, open building permits are not registered on title. They are filed with the municipality. So there is an additional search that must be done, which is an off-title search. And with those, we'll be able to learn if there's an open building permit, work orders, or any deficiency notices. Now, open building permits will continue to impact the property even after the transfer of ownership, and they do become the purchaser's responsibility if title is conveyed to them and that building permit is still open and active and not dealt with, and could inevitably lead to some fiscal obligations falling on the purchaser as well. One thing to note, just from our experience, we've been finding that off-title searches can take up to 10 business days, again, just depending on the municipality, because they do differ in their procedures and processes. But with that in mind, in our current market, and with these quick closings that we've been seeing more recently, it's just something prudent to note. If it's a search that needs to be done on the transaction, we obviously do need to be apprised as early as possible. An open building permit means that there's permit that's been granted for the work, but it's in some way not complete. Now, that could be that the work itself is incomplete. It could be that the work was done, but maybe it wasn't done as the permit had provided for, that it had to be completed as, or it may not be in accordance with the bylaws, or the work could itself just be finished and it just hasn't been inspected yet to be closed off. A municipal inspector could, though, issue a work order to remedy deficiencies and violations, and this will be at the cost of the purchaser following the transfer of title if it's not done before closing. And this is where speaking about open building permits is prudent, making sure that we just understand the impact that they could have in the future on our buyers. So the question becomes, does a purchaser have to close the deal if an open building permit is discovered? To be able to answer this question, we're going to touch on paragraph 10 of the ORIA Agreement of Purchase and Sale, some case law, and finally title insurance. On the slides here, I do have paragraph 10 of the Agreement of Purchase and Sale, which I'm sure you have seen and read before. I've got the first half here, and then on the next slide, I've got highlighted off and bolded off a few important sections of this paragraph. Paragraph 10 essentially touches on what is the valid basis of a requisition on title and what affords us, what are things that we're afforded to be able to search us on title. In particular, purchaser is noted to have a right to conduct searches, requisitions on title, to identify any work orders or deficiencies notices. If a work order is found, the buyer must requisition that the seller rectify or remedy the work order prior to closing or to obtain title insurance. And paragraph 10 acknowledges this. If the seller refuses to do either of those things, then the buyer may terminate the agreement of purchase and sale. Now, I do think it's noteworthy that, just to point out for our purposes, that open building permits are actually not addressed in this paragraph, which is where our concern stems, because it is not covered, and therefore, if there is an open permit, we don't have the protection of paragraph 10. So we turn to case law to see what it says about how to handle these open building permits for the purposes of our closings. The first case we're going to look at is Thomas and Carano. In this case, the buyer discovered that there was an open building permit for construction on the property. The seller could not close the permit before closing, but arranged a title insurance policy and even went a step further and offered a holdback to be used for any repairs, just in case any were incurred by the buyer post-closing, to ensure that the deal itself could close. Now, the buyer refused the title insurance and holdback and proceeded to terminate the agreement of purchase and sale. So the question before the court was, does an open building permit render the seller in default of the agreement of purchase and sale? It was found, yes, it was a default. And the reason was because the resulting work created by the open building permit in itself was substantial enough to be a precursor for a work order being issued in the future. So what happened with this case is essentially elevated an open building permit to becoming a cloud on title. So it was something that was a valid requisition for title for us representing the buyers. Now, did the seller and the act of the seller of arranging the title insurance remedy that default? Again, yes, the court found that the seller had committed to obtaining that title insurance policy for the purchaser. So the court compelled the buyer to proceed with the transaction despite there being an open building permit. Another case to look at is the Martins matter. In this one, the buyer discovered that there was an open building permit for construction of a dilapidated garage on the property. Now, in this case, it's interesting to note that the buyer had seen the dilapidated garage, knew that it existed, but unfortunately was not aware of the open building permit until they had already entered into the offer. The garage itself turned out to cost approximately $110,000 in order to demolish and rebuild, when some further pressing was made into what exactly was the open permit. Now, the seller refused to remedy or rectify the open building permit on the grounds that it was not a valid title objection because a work order had not been issued. Now, if it was a work order that was issued, their argument was then yes, it would be covered by the agreement of purchase and sale and would be a valid objection. But in this instance, because it was an open building permit, the seller refused. So the question before the court in this instance was, does an open building permit in itself that does not have an open work order, as we just discussed, go to the root of title? And yes, the reasoning the court decided was because the open building permit created a potential risk for the buyer, since it could lead to an inspection, and the inspection could result in a work order. And the work order may be of a substantial nature and may not be easy for the purchaser to be able to remedy or to close. So the court in this instance stated that an open building permit is not a minor defect. It actually goes to the root of title, and again is a valid objection to title and a valid requisition. So in this case, the seller had not shown good title for closing, and the buyer was actually allowed to terminate the agreement of purchase and sale. So what do we take from these two cases? The buyer, whenever there is an open building permit, may terminate the agreement of purchase and sale under the pretenses that the open building permit could result in work that may be substantial or significant enough to result in a work order, and that the seller is unable or unwilling to remedy or obtain title insurance on behalf of the buyer in order to remedy that open building permit for the buyer. Now, we're going to touch on title insurance. Everyone usually thinks, well, there's always title insurance. Won't they just give you coverage over it? For residential real estate transactions, yes, there is coverage. How this works is in a single family dwelling. Essentially, it's one of those what you don't know won't hurt you kind of situations. Off-title searches are not required for you to get coverage on a single family dwelling. What they will cover for, and there's a caveat on it, is that it's only a defect that could have been discovered in the results of an off-title search. So if the search results wouldn't have shown it, then it's not covered. But if they would, then yes, you would get that coverage. However, if we go about and do an off-title search prior to closing and we learn of a defect, this becomes a known defect and this will be excluded from coverage. Now, with a multi-unit dwelling, off-title searches are required for coverage, so obviously any sort of defect found will have to be remedied and rectified prior to closing. So what's our takeaway from these? Paragraph 10 of the Agreement of Purchase and Sale only addresses the work order component deficiency notice aspect. It does not reference expressly open building permits. With respect to the case law, despite courts allowing open building permits to be elevated to title-related issues based on the two cases that I presented earlier, it's prudent to note that an open building permit may not always go to the root of title. The courts themselves assess these open building permit matters before them on a case-by-case basis, and they really do have to consider the specific circumstances before them to discern whether or not it will in fact be deemed a matter that goes to the root of title. The question they really have to consider, and we have to consider in each matter, is how substantial of an impact does the potential defect that is created by the open building permit have on the buyer? If there's no substantial impact, then it may not be a title issue. And finally, obtaining title insurance. Yes, there is that coverage that can be put in place on a single family residence. However, that's only in an instance that we don't conduct the search. And by not doing so, we may just be delaying a potential costly issue for the buyer that they will have to pay for and remedy afterwards, or go through the process of dealing with the title insurance afterwards. So does the purchaser have to close the deal if there's an open building permit? The answer really is uncertain. Maybe, maybe not. So with that, how do we go about you protecting your client, given that uncertainty regarding the building permits, and making sure that we can have that addressed in the agreement of purchase and sale? Well, first off, if you're acting for the seller, please take precautions. Check if there are any open building permits that have not been inspected or closed, and deal with those potential issues in advance of entering into the offer. Have those conversations with your clients and find out what they're aware of and whether they'd be interested in conducting a search to be able to rectify those before closing. Otherwise, there could be an issue that could follow later into the transaction. Another one is to make sure that you're not adding additional representations or warranties into the body of the agreement of purchase and sale. It is satisfactory for you to just solely rely upon paragraph 10 of the agreement. It does not reference open building permits, so you can leave it at that and leave it to a case-by-case assessment of what would happen if there is an open building permit, unless your client does want a specific clause put in which case please reach out to us and we'd be more than happy to give one that's specific to your circumstances. Now, if you're acting for the buyer, we always advise you to inquire about the future intentions for the property for your client. If they plan to renovate, redevelop, if it would be advisable in those instances that a clause be added to the agreement just to give the buyer some certainty going into the transaction and for the future for the property they're purchasing. A sample clause that could be added to the agreement of purchase and sale when you're acting for the buyer. And this is in an instance the buyer wants to ensure that the open building permit will be removed or remedied, or in the alternative that they'd be able to terminate the deal if the seller won't remove or rectify the issue. In this instance, a great clause would be that the seller and buyer acknowledge and agree that the agreement of purchase and of sale shall be at an end and all monies paid shall be returned to the buyer without interest or deduction if the buyer discovers an open building permit and the seller is unable or unwilling to provide a remedy to the open building permit that is satisfactory to the buyer in the buyer's sole and absolute discretion. So here we're wanting to make sure that we protect the buyer. We allow the buyer to discern whether the remedy in itself is satisfactory for their own purposes and in that circumstance, as opposed to wholly relying upon title insurance just to cover over the issue that they may potentially have to deal with later. Another sample clause when acting again for the buyer would be if the buyer wants to ensure that the open building permit or the work order will be removed before closing. Here the seller represents and warrants that there is not nor will there be any open building permits or work orders filed against the property on closing. If an open building permit is discovered by the buyer prior to closing, the seller, at the seller's own expense, shall ensure same is closed and provide evidence of the closure on or before closing to the buyer or the buyer's solicitor. So here again, we are just ensuring that this will be removed. There's a reassurance here that there isn't anything, there will not be anything, but if it is found and a search is done, that it will be rectified prior to closing. So with that, if there's any, going through all these open building permit matters, if you do have any specific questions or concerns, please by all means reach out to me. I'd be more than happy to discuss this further with you, and in particular if there's any questions that your client is facing at this time with respect to open building permits. But really what we're trying to do here is make sure that we protect our clients the best way that we can at every step in the transaction, and ensuring that on the selling side and on the buying side that we're looking after them in case there are any of these pesky open building permits. Now, next up, we have Jason Lane, one of my colleagues. He's going to be discussing pre-construction agreements and HST rebates and the impact that COVID-19 has been having on that area of our practice. Thank you so much, and I hope you all take care. Bye now.
Hey everyone, hope you're all doing well today. My name is Jason Lane. I'm just one of the lawyers here at Woitzik Polsinelli. I've been a lawyer here for almost a year now, and before that I actually articled with the firm, and prior to that I worked in the summer as a summer student. During my time here, I have worked quite extensively on real estate transactions as well as uncontested family law matters. And specifically with regard to real estate, I'm often the one who will be reviewing any new build agreements or status certificate reviews for condominium resales. And as I'm sure you're all aware, supply of real estate right now is quite low. That's really a seller's market. And this is putting a lot of pressure on buyers to submit or sign offers with really short conditional periods or even none at all. And while we understand this, we do still think it's really important for clients to, completely understand what they're signing before they go firm. And just so that you're aware, we can generally perform a review of a new build agreement or a status certificate within 1 to 2 business days when a short conditional period is required. And additionally, if there's just no way for there to be a conditional period at all, if the circumstances determine that the clients have to go infirm, we can usually give a quick review prior to the client signing as well, if there's time for that. So just be aware of that. If you need that service, just reach out to us, and we'd be happy to review the documents for the clients. Yeah, clients, of course, even after they've signed the documents, they're still going to have more questions for you, as I'm sure you experience all the time. And this has just been increased exponentially in the wake of COVID-19. There's a lot more uncertainty. And so, of course, clients have even more questions. And from my end, I'm definitely noting that clients are increasingly asking about questions about new build agreements, especially with the delays that COVID-19 brings. And I find that a lot of the time clients don't fully understand the statement of critical dates and the Tarion addendum. So they're not understanding what the dates mean and what the builder is entitled to do with delays. So I'm going to walk through just quickly some of the things to note that are questions I get all the time, and I'm sure that you get them as well. So just to make sure that everyone is fully understanding exactly what the implications of a new build agreement are specific with the statement of critical dates and the addendum. So I'm just going to pull up a slideshow here to share it with you so we can go over a couple points. Okay, so I'm going to start by talking about the statement of critical dates in the Tarion documents. This, of course, lays out the dates that the builder hopes the build will be done by. Now, depending on whether we're talking about freehold or condominiums, there's either going to be a final closing date or occupancy dates set up in the statement of critical dates. This document also just outlines any notices required by the builder in order to delay closing. And of course, if the builder is not compliant with the documents, then the purchaser is potentially entitled to some delayed closing compensation. Now, there's a number of different types of dates that are laid out in the statement. So we have tentative closings, tentative occupancies, firm closings, firm occupancy. Of course, it gets somewhat confusing to clients. And the biggest thing to note here is that we have a firm closing date, and often clients see that and they say, oh, okay, the builder has to close by this date no matter what. It's a firm closing date. However, that's not the case. The firm closing date is just the latest date by which the builder needs to provide closing without having to pay any delayed closing compensation. So when we're talking about the latest date that the builder can provide closing, we're actually talking about the outside closing or occupancy date. And I'll read this slide here. Up until this date, the purchaser is not generally able to take exception to a closing date. For 30 days after the outside closing occupancy date, the purchaser is permitted to unilaterally terminate the contract, and delayed closing compensation is required. So this is actually the date where the purchaser has the ability to say, I don't want to be as part of this agreement any longer. I want to terminate it. And within that 30-day period, they can terminate and be entitled to their maximum $7,500 in delayed closing compensation. Now, important to note for clients as well is that if they don't elect to terminate the transaction during this 30-day period, then they've eliminated their option to unilaterally terminate, and then the builder is essentially able to delay, well, technically indefinitely, but delay until a delayed closing date. And they do have an interest in closing as well, so it's not like they want to just delay this indefinitely, but they do technically have that option after this 30-day window ends. Of course, the main reason that clients are asking about the statement of critical dates is because they want to know if they're going to be able to be compensated for delays that the builder has notified them of. And as I'm sure that most of you are aware, delayed closing compensation in the Tarion addendum is capped at $7,500, and it's calculated at $150 a day. So this is generally $150 a day that closing is delayed past the firm closing date. Now, of course, there's other situations where a builder could provide insufficient notice and there's actually delayed closing compensation payable. But generally speaking, the client just wants to know, they've delayed past my firm closing date, how much money am I entitled to and when can I get it? So to speak generally about that, the delayed closing compensation, the purchaser needs to make a Tarion claim within 1 year of closing or occupancy, or if they've unilaterally terminated the agreement as of the outside of occupancy or closing date, just within 1 year of that termination. Occasionally, builders will agree to pay out any delayed closing compensation as part of the final adjustments. However, this isn't terribly common. They generally would rather the purchaser go through Tarion. Just so that you are aware, and you can provide this to clients as well, Tarion's website does offer a statement of critical dates calculator, which will just provide required notice dates and when delayed closing compensation may become payable. So you can just have clients Google that and they'll be able to find the statement of critical dates calculator there. And now speaking, this is going to speak to what the impacts of COVID-19 have had on this, is talking about whether the statement of critical dates can be changed. And the only way that they can be changed once they've been agreed upon by the client and the builder is by mutual agreement or when there's an unavoidable delay. So of course, for there to be mutual agreement, the purchaser is going to need to agree to that shift. And so the only way that a builder can unilaterally change the statement of critical dates is if there's an unavoidable delay. And an unavoidable delay is defined within the Tarion addendum, and it includes strike, fire, explosion, flood, act of God, act of war, terrorism, pandemic, and then any period, which is typically called a remobilization period, where the vendor requires time to pick up the pieces and get back in working order. And again, this is what it specifically stated, that they can delay the closing dates without having to pay any delayed closing compensation. So the primary thing that this means for clients is they have the ability to shift the firm and outside closing dates, because these are the ones where a client would be entitled to delayed closing compensation or would be entitled to unilaterally terminate the contract. One of the issues that COVID-19 brings when we're talking about unavoidable delay is that based upon the wording of the Tarion addendum, a builder can technically shift the statement of critical dates by the entire length of the pandemic. So if we're going by the wording, the pandemic's been almost a year now. That means technically the firm and outside closing dates for any agreement signed prior to being declared a pandemic can be shifted by the full length. And we have no idea when it's going to be declared that there is no longer a pandemic. Because this situation is so unprecedented, there's very little case law or tribunal decisions in order for us to advise clients on whether a court's going to determine that these delays are reasonable. So a builder may have shifted their date 8 months. A lot of times clients will say, oh, well, I've been to the area, or I've seen other builds by this builder and they're building, why aren't they building my house? And the reality is we don't really have a way to advise because again, this pandemic is still ongoing. It's really hard to say what the builders will be permitted to do and what will be considered reasonable. At this time, though, it's still most prudence for clients to presume that builders have followed the addendum by declaring the pandemic an unavoidable delay. And it's prudent to presume that these will be considered reasonable and that delayed closing compensation will not be payable as a result of the unavoidable delay. And another thing is that clients, a few of them have been noting that when they get notices of the unavoidable delay, that they don't have an estimated time of the delay. And the reason they bring this up is because they've read through the addendum and they realize that notice was supposed to have had the estimated amount in order for them to have provided proper notice. And while it's true, the addendum does require written notice and it requires an estimate of the duration of the delay. It's already been established even before COVID-19 that builders are considered to have complied with their obligations under the unavoidable delay procedure, even if they haven't provided an estimate when it's not reasonable to do so. For example, there was a case where there was an elevator strike and it was impossible to complete a building because the elevator workers were on strike and there was no determination of when this would end. Builders were not giving an estimate and it's already been declared that that was reasonable for them to do. So overall, with regards to closing dates and the Tarion documents, it's really important for clients to know, especially heading into the agreements, that especially during COVID-19, the builder is going to have a lot of leeway with regard to when these transactions and builds actually complete. And the clients need to be aware that it's possible they won't be entitled to any compensation, and it's possible that these could be delayed, up to a year or more, depending on the results of this pandemic. And as long as clients are aware of that, they can plan accordingly. So I know this has been quite brief, but I really appreciate the opportunity to be able to share with you, some of the questions that I get asked quite a bit about new builds. And certainly if any of you have any specific questions about these types of agreements or with regard to status certificates as well, I'd be more than happy to answer any of those questions. So you can shoot them my way or give the firm a call and we can discuss those further. I hope that at some point when COVID-19 has been dealt with, that I can meet a lot of you in person, as getting a little tired of Zoom, but it's what we got right now. Thanks a lot and have a good day.
Hi everyone, my name is Vanessa Romanino and I am part of the Woitzik Polsinelli team. I've been with the firm for many years now and I mainly practice in the estates group, and I occasionally jump in the real estate to assist. So today I wanted to jump on here just to answer some questions about how estate work affects real estate. And it's been coming up a lot more lately, and questions surrounding that process and what we should be looking at. So today we're going to be talking about probate, what the process is, if there's any exceptions to probate, and what you should be looking for if you have a seller that either passes away after they've signed the agreement, or somebody approaches you and the owner of the property has already deceased. Okay, so just to jump right into it, we're going to start with probate. And the big question is, what is probate? So probate is a process where we actually hand in the will to the Superior Court, and the court kind of puts their seal of approval on the appointment of the executor, which allows them to actually act as the executor. So what does that mean with respect to real estate? Well, it means the executor then has the authority to transfer or sell the property. So when is probate required? So not always. We have some exceptions where a probate application is not always required. So mainly we're referring to what we call the first dealings exemption. So under the first dealings exemption, if a property was purchased in the old registry system, the individual can, what they say, die in the registry system, meaning that no probate is required. So how we find that out is we pull a title search and we examine whether the property was purchased in that system, whether it's been converted. If it has been converted, we look at the date of conversion and see if it still applies. So if that's the case and no probate is required, then that is great. We proceed and we sign what we call an indemnity agreement to the land titles office, which essentially waives any liability to them for transferring the property. Now, the problem becomes that is a very narrow exception. So generally speaking, probate will be required to transfer real property. So the process is we have to gather a bunch of information from the clients, and we file a probate application with the Superior Court in the jurisdiction where the deceased passed away. So when we do that, we have to file the estate administration tax with the application. So the estate administration tax is 1.5% of the estate. So the first $50,000 is exempt. Anything above that will be subject to that tax. So unfortunately, even where we have a property that has qualified for an exemption, so under the first dealing exemptions, for example, so the property itself can be transferred without requiring probate, but then we have a bank account that triggers that need. So the bank's saying we won't release this money without probate. Now, unfortunately, all assets need to be included. So even though the real estate was exempt, it now has to be included in the application and estate tax payable, which is unfortunate. So we include all assets owned by the deceased at the date of death. That will exclude, so we take out assets that are jointly held or assets that have a named beneficiary, because those will not form part of the estate, they will flow outside. So we file that application and the court will review it and determine, they authenticate the will, and then they grant the probate application to the executor, which again gives them the authority to act. So that kind of leads me into joint assets. So it's not required if we have a joint property. So when you are joint on a property, you have two owners. So where we have real estate, if two owners are joint tenants, it will pass by what we call a right of survivorship. So if one tenant passes, it directly goes to the surviving joint tenant outside of the estate directly as named. So that is great, and it will not go through any probate application. The probate application will generally happen when assets flow on to children. So that's why we typically avoid it when we are dealing with spouses, because they're going to be joint on their property, most likely. Their bank accounts are going to be joint. If they have any investments, it will flow to the survivor of them as a named beneficiary. So then we run into the issue, if we have to probate a will, and we have to pay the estate tax, what happens if the estate does not have the money to pay that tax? Unfortunately, it is difficult and it makes it more complex to have to submit the probate application without having the estate administration tax paid with the application. That's not to say that you can't do it, but it does make it more difficult. So the executor family members can lend the money to the estate, and it will be paid back as a debt of the deceased before any other monies are distributed. So in an estate, all the monies come into a pool, all just debts are paid right off the top. That would include any funeral expenses, any creditor debts, any income tax liabilities, and would include if the estate administration tax was paid. So that can come right out of the sale proceeds. And then of course, whatever is remaining out of the net proceeds would be split among the beneficiaries of the will. So what happens when a seller signs the agreement of purchase and sale and then subsequently passes? So the case law is unclear as to whether they would be bound, but there is a clear breach of contract. So in my experience, where a seller has passed away, so the agreement has been signed and the seller passes away and probate is required, we can expedite that process by marking it urgent. I typically call the court in advance to let them know that it's coming in, and they will pull it and deal with it right away to try to accommodate the closing date. That's not to say that we wouldn't necessarily need an extension, because most often we do, but that is the only instance where they will mark it as a rush file and take it out. They will not do so if somebody has deceased and there's just urgency to sell the property. Okay, that it's only where the deceased has signed the agreement and then subsequently passed away. So we can't rush the file otherwise. And each court has a different timeline. So unfortunately, if we were looking at the Toronto Superior Court, we're looking at, I would say, 6 months to a year to obtain a probate application. If we're looking at a Durham property, currently my experience has been about 4 weeks, which is very good. And similar to other jurisdictions like the Newmarket Court and Brampton. But I always advise clients to look at about, I would say 6 to 12 weeks, just to give it time to come in, and that those are simpler estates, okay, where there's a will and we don't need to get any orders or bonds placed. So again, stressing the importance of having a will. Where there is a will in place, there is an executor appointed. Everybody knows where the estate funds are going. Where there is no will, we have to rely on the legislation to tell us. So for example, where there is no will, the property of the deceased may be administered by the spouse of the deceased, or somebody living in a conjugal relationship with the deceased, or the next of kin. So how can this complicate things? So what if you have a situation where you have two parties that were married, never formally separated or divorced? Now that person will have a prior right to be appointed as the executor. So when we file that probate application, we would need them to renounce that prior right. And then because we don't have a will, there is the requirement to post the security bond. So if all the beneficiaries are in agreement, we can get an order to dispense with that bond. But again, we're just adding layers of complexity and costs because of time, right? So we want to avoid that wherever possible. Another big question that I seem to get is how to label the seller. So on an agreement of purchase and sale, the owner has deceased. So 2 ways: you can simply put the estate of John Smith, or you can put Vanessa Romanino as executor for the estate of John Smith. So that brings me into my next point, the difference between a will and a power of attorney. So I often see agreements come in where it will say Vanessa Romanino as power of attorney for John Smith. That would be incorrect if the owner has deceased. So a power of attorney is a living document. It is while you're living, if you become incapable to manage or make decisions for your property or your personal care. Where you have passed away, that is where your will takes effect and kind of takes over, and that's where the difference between an executor and an attorney is. So if you have a client who is incapable, then of course you're relying on a power of attorney, that would be correct. But if you have a client who has deceased, we're looking at the executor and the estate. Also leading into points that where we have a power of attorney that we're trying to rely on, so whether the client is out of the country or they are incapable, it's best to have that power of attorney reviewed before we commit to an agreement of purchase and sale. Why? So some power of attorney have restrictions. We have continuing power of attorneys, which are effective immediately from when they are signed, and they will continue to be in effect once somebody becomes incapable. But then we also have what we call springing power of attorneys. So they will only spring into effect when somebody becomes incapable. So in that example, it would, and generally there's an assessment required or some sort of stipulations in the document as to how to determine capability. In that case, if somebody was just overseas, for example, we would not be able to rely on the power of attorney. Also, if there was restrictions, conditions in the power of attorney, that could affect being able to sign the agreement of purchase and sale, and of course, making sure that it was validly executed. So that is an issue as well. So always important to have that reviewed prior to signing that agreement. It happens very often. We just get emails saying, we have this power of attorney, this client's looking to sell. These are the circumstances, this individual is in a home, they suffer from Alzheimer's, dementia, whatever the situation may be. But then we need to look at the power of attorney, look at, are there any restrictions we need to be worried about? Whose name does the attorney? Is there one child? Are there two children? Are they named jointly where they have to act together? Or are they named joint and several where one can act without the other? Do we need a doctor's note to confirm incapacity? All of those things. So those are the two main areas where I think that estate law crosses with real estate, being the probate applications and dealing with property of a deceased person, or dealing with property when we have a person who has signed an agreement and then subsequently deceased, and powers of attorney. So I hope that that helped answer any of your general questions. I'm always happy to help and available via email, which is just at Vanessa, VANESSA, at durhamlawyer.ca. And of course, you can always give our office a call and we would be happy to help or assist. Thank you very much and hope you have a great afternoon.
So, hi there, my name is Andreina Minicozzi and I am the family lawyer in the Whitby satellite office for DSF. So for today's presentation, we're going to be talking about basically cohabitation agreements and separation agreements, and why is it a good idea to have, okay? And what is the distinction between cohabitation agreements and separation agreements? So the distinction basically with the cohabitation agreements and separation agreements, the word already says it. Cohabitation agreements is a written contract between married or unmarried couples. They may be living together or they might be contemplating living together, and they want to set out some provisions in the event that they were to separate in the future. So they are not planning to separate. They are basically protecting their rights in the event of separation. Separation agreements are the opposite, and that's usually what I tend to get in my family law practice. Either I get retained for a separation agreement, or I get retained in order to proceed with court, okay? So separation agreement is a written agreement between married or unmarried people that sign after they separate, okay? And in that contract, you talk about everything: custody, support, property matters, without having to obtain a court order. When I say usually I get retained for separation agreements or to proceed with court, is because the parties cannot make a separation agreement or a written contract. They cannot come together into fruition and prepare this written contract. Therefore, the only way to resolve the matter is by attending court. So why do we need that? Why do we need a separation agreement or a cohabitation agreement? So cohabitation agreements does not need to be signed before the couple gets married, or it doesn't need to be signed before the parties actually move together. They can be drafted in contemplation or anticipation of marriage. However, there is a lot of cohabitation agreements that are written in such a way that if the parties were to get married, then that agreement or cohabitation agreement gets not null and void. With the same token, there is also cohabitation agreements that are written in contemplation of marriage, and therefore it becomes a marriage contract automatically. So that has to do with whether you add that clause into the cohabitation agreement or not. And as I said before, couples may sign a cohabitation agreement to set out what will happen if they separate or if one of them die. In doing so, they opt out of the laws that usually apply with respect to spousal support, property division, and many other issues that may arise upon separation. Because with the cohabitation agreement, you have the option, for example, to say there is a waiver of spousal support. So even if and there is also a clause that in the cohabitation agreement that upon marriage, it becomes a marriage contract. And if the parties do decide to separate after, let's say, 10 years from now, and there is a waiver of spousal support, that waiver of spousal support will apply. So that is important for you to contemplate. A separation agreement basically has the same effect, but it's usually once the parties have separated and they're not in the best terms ever. So they discuss everything about custody, access, resolving matters via mediation and arbitration, okay? So what can a cohabitation agreement do for you? So the cohabitation agreement, in the cohabitation agreement, you can talk about ownership or division of the property that you currently have. That you don't want. For example, if you have a cottage and you have a property that you both currently live, you may put certain provisions in order to talk about what will be the division of that property upon separation. As I mentioned before, you can also talk about spousal support. So you can put a waiver of spousal support in your cohabitation agreement, which a lot of people do. Also, you can talk about child support, but bear in mind that you cannot necessarily reduce guidelines of child support clause. You can only make it if the agreement is reasonable. So let's say you want to say in the cohabitation agreement that you don't want there is a waiver of child support in the cohabitation agreement, and they tell me they want that waiver, there is not such possibility. You cannot waive child support. You can basically increase child support or say that the parties will work in a child support provision that is agreeable between the parties. But you cannot necessarily waive anything related to child support because you need to follow the child support guidelines. And you cannot necessarily talk in your cohabitation agreement about custody and access of your children in contemplation of separation. The only thing that you are allowed to do is basically direct the way that education and moral training for the children will be. Separation agreements, on the contrary, can discuss, upon separation, you can discuss everything. So you discuss custody, access, equalization, child and spousal support, pension division, state matters, and divorce. So what is the difference between married and unmarried couples? So the best way to describe it is married couples are basically more protected in terms of equal division of all of the assets and debts that you got upon the date of marriage and dissolution. Even if you were cohabitating with this person before marriage and then you marry later on, for example, you were living 2 years before marriage, that is also going to be contemplated upon the equalization, okay? Common laws does not have a right for equalization. What you have the right is basically if you own a property jointly, then you get to divide that property on an equal basis. You may also have a claim for spousal support if you lived with this person for a long period of time. But as I said in my slide, married couples have a right for equalization of the net family property. If your spouse owns a property and an asset that are worth more than yours, you're obligated to transfer half of the difference in value. And the same with equalization of the matrimonial home. Even if the other spouse owns the property before marriage, you have to equalize the matrimonial home because that is a matrimonial home and it has a different extension in law in terms of division of property. And even if you're not on title of that matrimonial home, you need to equalize that matrimonial home upon separation. Common law is, it has no statutory regime for division of property. Each party keeps the property that they own prior to the relationship and equalize whatever they share assets. So they, for example, as I was talking before, if you own a property jointly, then you have to divide that property jointly as well. But if you're not on title of a property, so let's say you guys lived together for 10 years, but you're not on title of that property, then the only remedy for that common law spouse is basically to put forward an unjust enrichment claim. And in order to prove this is very difficult. It requires a lot of evidence. And that's why most of the time you need to litigate it in court in order to see what the judge will say about it. So what is an unjust enrichment claim? So if you, as I explained before, if you're in a long-term relationship and you're not on title and yet you contributed extensively to a household and then you guys separate and then he keeps the household and you keep nothing, then that's what it will constitute an unjust enrichment claim. So one of the things that I've been asked frequently when the parties come here for a consultation is what happens to the increasing value of a matrimonial or a family home after separation. And why do I put in brackets family home? Is because if you're in a common law relationship, it's not called a matrimonial home, it's called a family home, okay? So when a marriage or common law relationship breaks down, the question that arises often is who benefits from the increase of value of the matrimonial home after separation? For common law spouses, generally the spouse on title keeps the house and gets profit exclusively to him or her. But if the spouse, but it's not like a black and white situation, if the spouse is not on title, but is determined through evidence that he or she has contributed a lot into the mortgage payments and property taxes and renovations of the home, then the story is a bit different, okay? Because he or she may be entitled to a portion of that home, of the proceeds of that home. So the entitlement has to be basically litigated in court in order to see if he or she will be entitled to 30% of the value of the home. So the increase in value of the home. So that is something that has to be proven through evidence, okay? And that's very costly. As to the reason why I think that people should have a cohabitation agreement contemplating what is it that they want to do with certain properties, especially if you're not on title. So I am talking now about example scenario 1. So let's say only one spouse is on title and that spouse stays and pays all the bills. So what happens to the increase of value of the matrimonial home? That is a very simple scenario. Basically, if the party is on title and he or she is the one paying for everything of the home, including mortgage payments and property taxes and any renovations, then basically the one that is getting the benefit of that increased value should be the spouse on title. This is a more tricky scenario. What happens when spouses are both on title, only one remains in the house and the other one is the one paying for all of the costs in the house, meaning so he or she is paying for the mortgage payments, property taxes, renovations, and utilities. So utilities is not something that the court will contemplate because it's something that you use personally. But in terms of mortgage and property taxes and renovation, that's something that the court are interested to see how much renovations and how much property taxes you had to make in order to increase the value of the home. So if the presumption is that both parties will get the increase of value of the matrimonial home. However, it's not that simple because if the other person that pays nothing gets advantage of the increase of value of the matrimonial home, then they need to equally contribute back to the other spouse for everything that he or she had to contribute in order to make that happen. So for example, let's say that I list that the parties separate about a year ago. And the wife basically is the one making all of the mortgage payments, property tax payments, and utilities and renovations in order to list the house for sale in a year from now. So that year, the increase in value of the home has been 100,000. And part and parcel, it has to do with the fact that you also renovated certain areas of the house in order to make it more marketable to in order to make it more marketable out there, and then therefore the increase of value of the house is 100,000. So then what I will see is basically how much she needed to pay in terms of mortgage, property, and renovations. I get the evidence and the receipts for all of that. And then basically if the other party wants that increase in value, they need to reimburse basically my client or the wife. They need to reimburse her with half of everything in order for the other spouse to receive half of the value, okay? anyways, that's everything for today. And if you have any questions, I don't think you can ask me directly, but you can always email me all of your questions. Thank you very much.
That brings us to the end of our presentation. We hope that you found it informative. We hope that you enjoyed it. We hope that this platform worked, and maybe it's something that we can do again in the future. If you have any questions that have arisen as a result of anything that was discussed here today, please feel free to reach out to any one of the presenters or to myself, and we are happy to chat with you with respect to any of these issues, or if you have any burning questions about any other issues that we didn't discuss on this presentation, we're happy to discuss them with you. If it's file related and it's a file that is not in either one of our offices, please don't let that be a hesitation for you to call. We're happy to chat with you and happy to help you to resolve any issues that you may have that arise in any of your files or in terms of dealing with your clientele. We want to be a resource for you. We want to be firms that you can look to and partner with, and we can work together. That is the goal. And again, thank you very much for attending today. DSF is located at 209 Dundas Street East in Whitby, so right at the Four Corners, just east of the Four Corners. And Woitzik Polsinelli is located at 619 Brock Street South. So you can reach out to us, pop by. Obviously, it's COVID right now, so visits in person are a little difficult, but we are in the office. We are accessible, and we are happy to be there for you. And if you have any questions, please reach out.
Thanks a lot and have a good day.